Under the law, disability means anyone who's 14 years of age or older who is showing a pattern of conduct that demonstrates they're unable to manage their personal affairs and/or their financial resources. In Kentucky, before someone can be declared what's called disabled, they have to go through a jury trial process. And if they are determined to be disabled, then they will have a guardian appointed for them. And what this means in practice is someone to care for their personal needs, take care of their finances, help them make medical decisions, all those day-to-day living activities that they need assistance with. Usually when someone is looking to file guardianship, one of four things has happened. Either they have a child who has some sort of a mental or physical disability diagnosis who's turning 18, and in order to continue to care for their child and to deal with medical providers, they need a tool in place to be able to have the authority to do so. Or there's someone whose loved one is now elderly and has gotten a diagnosis of dementia, for example, and now lacks the capacity to continue to manage their affairs. There's also situations where someone has suffered a severe medical emergency and they need someone to be able to make medical decisions for them. And fourth, there's also those who have a family member who's got severe chronic mental illness, and through a series of incidences where they're non-compliant with their medications, for example, they just need someone in place to be able to make and manage decisions for them based on their inability to do that for themselves. The guardianship statutes are set up so that we are both protecting the rights of individuals so that they don't get taken away wrongfully, but also set up to try to give loved ones all the tools that they need to care for the person who's no longer able to care for him or herself. So what happens is the loved one, the family member, will come in and they will start the whole process with the filing of a petition. This petition is going to ask for information about the respondent, that's the person we're talking about, where they live, their age, and the nature of their disability. So what is it that's now making them no longer able to make good decisions for their personal welfare or for their finances? Once that petition gets filed, then a 3-person interdisciplinary evaluation team is going to meet and evaluate that person. That's going to be a social worker, that person's primary care physician most likely, and also a psychologist. All 3 will evaluate and then tender their evaluations back to the court, and we will have that to be able to tell the jury what those 3 professionals have said as to that person's ability to care for themselves. One question that I usually get asked is about someone who has power of attorney over someone else and whether or not they need to file for guardianship. Usually I tell that person that it just is going to depend on your particular situation. If you are successfully using that power of attorney, you may not need to go through the guardianship process. However, someone, for example, who's turning 18 has never had the ability to make a power of attorney to begin with, so that parent is going to need to go through the guardianship process. Something that's very helpful is to bring with you the name of the treating physician that the person usually sees, because the court is going to need to know that so that they can send the proper doctor the report to be filled out and filed with the court. There are different levels of guardianship. There's full guardianship, which means that the guardian would have the ability to manage all aspects of the person's life, make medical decisions, living arrangements, financial decisions. There's also a limited guardian, and that's for someone who lacks the ability to manage some of their personal or financial affairs, but still has the ability to make some decisions. And the court is going to designate what abilities that limited guardian has with respect to the person that they're helping. There's also just a conservatorship. Sometimes people are just looking to assist someone with their finances and don't need that extra level of management with the personal affairs. And so you can seek for just conservatorship, which would grant you the ability to manage the person's financial resources for them. There are certain instances where someone needs immediate guardianship over someone, and in those instances, a person would just file for regular guardianship, and then they would come to our office and they would fill out an application for emergency guardianship. The hearing would be held very quickly, and if necessary, then the court would appoint someone as the emergency guardian so that they could make those immediate decisions that are necessary until the regular guardianship hearing can be held.